Hello everyone! Today we are going to discuss an important topic in forensic medicine, witness. One of the most important sources of evidence is the witness. A witness may be an ordinary person who has seen an incident, or a professional who provides expert opinions based on specialized knowledge. In simple words, a witness is someone who tells the court what they know about an incident or event. An important point to remember is that the law does not restrict witness competency based solely on age or mental condition. What really matters is whether the person can understand the questions asked and provide rational answers. Broadly, witnesses are classified into two major categories: common witnesses and expert witnesses. Let us first understand the common witness. A common witness is an ordinary person who gives evidence only about facts that he or she has personally seen, heard, or observed. For example, a person may come to court and say, "I saw the accused hitting the victim." This statement is acceptable because the witness is simply describing what was directly observed. However, suppose the same person says, "I think the accused is mentally abnormal." Such a statement is generally not acceptable because the witness is expressing an opinion without having any specialized expertise. Therefore, a common witness is expected to speak only about facts and not about professional opinions or conclusions. Having understood the common witness, let us move on to the second and very important category, the expert witness. An expert witness is a person who possesses special knowledge, skill, training, education, or professional experience in a particular field. Examples of expert witnesses include doctors, fingerprint experts, handwriting experts, ballistic experts, and chemical analysts. To understand this better, imagine a doctor examining an injury. The doctor may state that the injury could have been caused by a sharp weapon. This is not merely an observation. It is a professional opinion based on medical expertise. Now that we have discussed the different types of witnesses, let us look at an important offense related to witness testimony, namely perjury. Have you ever wondered what happens if someone deliberately lies in court? This act is known as perjury. Perjury means intentionally giving false evidence after taking an oath before the court. In simple words, it means knowingly lying in court. For example, if a person knows the truth but deliberately gives false information to mislead the judge, that person commits perjury. Since the justice system depends on truthful evidence, perjury is considered a serious offense. Under Indian law, BNS Section 227 defines false evidence, while BNS Section 229 prescribes punishment for giving false evidence. The punishment may extend up to 7 years of imprisonment along with a fine. Moving forward, let us discuss another frequently asked topic, the hostile witness. Sometimes a witness gives one statement to the police during investigation, but later changes that statement while giving evidence in court. Such a witness is known as a hostile witness. For example, a person may initially tell the police, "I saw the accused committing the crime." However, when the same person appears in court, he may say, "I do not know anything about the incident." Thank you for watching. I hope this discussion helped you understand the concept of witnesses in forensic medicine more clearly.